Welcome everybody to today's seminar. The seminar today is hosted by the Health Law and Ethics Network, the Health Law and Emerging Technologies Group, and the Centre for Artificial Intelligence and Digital Ethics here at University of Melbourne. I'm Associate Professor Colleen M. I'm one of the directors of the Health Law and Ethics Network. I'd like to start by acknowledging that we meet today on the unceded lands of the Wurundjeri people of the Kulin Nation, and pay our respects to their elders past, present and emerging. And I extend an especially warm welcome to any Indigenous colleagues who are here in the room with us today. It's my very great pleasure to welcome Professor Colleen M from the University of Ottawa, who's going to be presenting the seminar today. The topic, Machine MD, 6 case studies of the law and ethics of health-related artificial intelligence in Canada. It's really wonderful to welcome Colleen to the Melbourne Law School. Colleen is a professor at the University of Ottawa Faculty of Law. She is the research chair in health law and policy, and she's the inaugural director of the University of Ottawa Centre for Health Law Policy and Ethics. Colleen hails from New Zealand, but has lived for the past 25 years in Canada, working at the University of Toronto and now at the University of Ottawa. She is an expert in the area of health law and policy, and we are really delighted that you are here with us today, and it's wonderful to see such a great group of colleagues and our students who are here today. Thanks, everyone.
Thank you very much, Colleen. And lovely to be here in beautiful Melbourne again. It's been a while. I think for many of us, we could say that it's been a while for a lot of things. So lovely to be here. Thank you to Paula for helping organise for me to be here, and to HeLEX, to the law group, and the Centre. There's a lot of acronyms. The Centre for Artificial Intelligence and Digital Evaluation. Ethics. There we go. Perfect. I will get my head around them all. It's sort of, I think, once you get into the zone, you have a lot of different acronyms flying around. So I want to talk to you about work that I started doing a few years ago now, just before the pandemic. I was telling Paul I was trying to make a decision about whether to focus on public health and pandemics or artificial intelligence. I picked artificial intelligence, and then a pandemic happened. So I've actually spent quite a bit of time working on the pandemic and not as much time working on this, but we still have got going. We got funding from the Canadian Institutes for Health Research, a multi-year project. And so this is some of the fruits of this research. And these are some of our funders. And my colleagues who helped lead this work with me, Teresa Scaza, I was mentioning her in conversation before. She's a leading privacy law expert in Canada. Catherine Regis, who is a health law scholar in Quebec, in Canada. And then Anna Goldenberg, who is an innovator, an AI innovator working at Sick Kids. That is the team, but we have many others who are involved with that as a leadership team. So, I think most of you are aware that AI is already transforming many parts of our lives, and it is transforming healthcare very quickly. And there is a huge promise here to improve upon safety and quality in healthcare, where we know there needs to be vast improvements made, and access to care. So there's a lot of hope, but it raises very, and sometimes very significant and novel legal and ethical questions, and sometimes just emerges old ones that maybe need new solutions because of the way that the innovation is proceeding apace. And so we started this project with the idea that we want to really explore, can our existing laws meet, the challenges that health AI is putting to us, or do we really need major legal reform? Do we need, tailored bespoke laws for health AI, or can we rely upon our already very heavily regulated healthcare area to meet the needs? And so that's how we started this. And I think, most of us, well, at least perhaps not you, but me, grew up watching too many Terminator movies, right? And so when we were reading the sort of literature here, a lot of the folks in humanities and arts, there's a lot of hand-wringing, general hand-wringing about the prospect of AI, but without a lot of depth. All right, so a lot of general concerns raised, sort of throw the brakes on, but not a lot of tailored sort of insight. And so what we thought we would do is try to get into it a bit more. So what we felt was if we could work on particular case studies of actual health AI across the spectrum, we spent ages trying to figure out which ones to choose. But to be honest, the ones that we ended up choosing were often what we needed was a willing innovator. So we needed an innovator who would work with us so we could deeply, as best as we can from a legal perspective, understand what the innovation is trying to do, what its strengths and weaknesses are, what its application is, what its benefits are. So we felt by digging into the actual technologies that we would be able to say better and more real things about the adequacy of existing laws, whether new laws need to be promulgated, and so on. So the case studies work that we got into a room. There's usually about between 30 and 40 of us. Post-COVID, it became a Zoom room, but that's just seemed to work real fine. And a mix of legal experts, innovators, clinicians, patients, and government. So we tried to bring this group together to sort of get into it in a more deep way. We would have pre-meetings with the innovator to understand the technology and with a selected group of legal experts. So usually we would have someone who would be the expert on privacy, would be the expert on informed consent, be the expert on liability. And then at the workshop itself, the innovator would present the innovation, and then the legal experts would do sort of short presentations. Then we go into breakout groups, then we come back into a big group. And so we wrote up reports for each of these case studies, and I'll show you the URL link with CIFA, the Canadian Institute for Advanced Research. They help support this. So I was just telling Paula my struggles to learn French. You want to read it in French, baby, you can do that too. French and English versions are available on the CIFA website. So let me just, and I should mention, I think a really important piece of this is that we involve patients throughout our case studies, and they were fantastic. They really asked all the hard questions, actually. So I highly, I love that. So here's one. I probably won't have time to really go into all of them in any depth, and you can read about them on the website. But this one, I work quite closely with this chap, Dr. Devon Singh. He is actually Australian. He's an amazing guy. He's an ER doctor and a computer scientist. So I don't know how you get that talented, but he's doing clinical innovations in sick kids in Toronto. And he created this tool, which basically a kid comes into the ER, appears to have a broken bone, not sure, waits for hours to see the ER doctor, then gets told to go have an X-ray, blah, blah, blah. This speeds it all up. A nurse or whoever really inputs the data of the kid into the algorithm, and it will spit out X-ray, no X-ray. The kid that doesn't go for X-ray will just wait to see the physician. So there's really no downside from that perspective, but it can hugely speed up the ER triaging time, processing time, liberate resources, and so on. Devon is working on a number of these kind of triaging tools in the pediatric area. And so here we were exploring the liability issues. So interestingly, in-house counsel were, really putting the brakes on him developing this. And we were like, what is the problem? So that was an interesting kind of division of views there, informed consent and liability. This one, the actual innovator of this one is a guy called Theodor Grachanov. His colleague Frank was the one who presented it to us. It's a sort of safety and quality improvement tool. So they videotape all of the surgical encounter everything that from woe to go. And then they use AI to de-identify the whole thing, and then they use a human to make sure that the AI has not actually missed anything, like funny flowers on your Crocs or something in the OR. And then they use it as a safety improvement mechanism. So they go through and they look for mistakes, near misses, and they use that to help train the surgical team. This is actually being deployed, interestingly, although developed in Canada, first in the US and the Eastern Seaboard, so it's already in use and is now being used in all the major academic hospitals in Canada on the eastern side anyway. And we were exploring with this team about the possibility of using it in real time, so that it would in real time sort of check the decision making of the surgical team. You picked up the green line, like our data would say the blue line, not forcing them to do anything, but giving them the assist. And so, in this kind of paradigm, they're actually protected by kind of quality improvement protections around liability. So moving out of that space and into the real-time space is a lot more issues around potential liability for things that go wrong. This was a really interesting one. This guy, Zachary Kaminsky, is a local psychiatrist in Ottawa. Again, another clinician innovator. Watch this space, folks, be careful. He's mining publicly available Twitter data for suicidal ideation. So by looking at the narrative that one has on and how that changes over time, they can tell whether you're moving in or out of depressive sort of states and so on. And so this is very early days for Dr. Kaminsky with this. He's considering commercial applications, some of which are more kind of horrifying than others. So one of the horrifying was to be used by employers. He might not think that was horrifying. We thought it was a little bit horrifying, but perhaps less so in the primary care setting, whereas if you agreed to it and your family doctor could be informed of changes in your moods that might help them treat you from a primary and preventive care perspective. So some of this was interesting where we could kind of intervene in the technological development. This is more out there. Some of you might have heard about this idea of a digital twin. This is our colleague, Abed Al-Sadiq. He is an engineer. And the idea of a digital twin, they already kind of do this apparently for airline planes and so on. So they'll create a perfect digital replica of the plane made in 2017 on this date and this time and these weather conditions by these people and, all of its history. And then they can test it for different potential things to go wrong. So the idea with this is that they could do this for humans. So they could create the perfect digital replica of Colleen. And unlike Colleen, they'll actually remember everything that happened, dates and times, employment, environmental contaminants, and da-da-da-da-da. They can also do it for particular organs. So they can test, if they're going to try a new heart medication, they could test it on my digital heart before they test it use it on my real heart. So this would be kind of personalized medicine really to the max. So really fascinating, but still early days on this. So many concerns from a privacy perspective, obviously, but also questions of the legal self and who decides, maybe digital Colleen is actually a better decision maker for Colleen than actual Colleen. So this may be increasingly true. This is my colleague Anna Goldenberg, who's part of the leadership team. She too, with Devin, work at Sick Kids. She's not a clinician. She's an innovator. So there's a 9-year-old kid that broke his femur, ended up going into cardiac arrest and had brain damage and other terrible things happen to him. And that was the motivator for her to work on this. So in the ICU, many data points coming at the clinical team, very hard for them to know which one to look at first. And so this tool helps them predict cardiac arrest. So if you can prevent cardiac arrest, that's really important, because as a kid goes into cardiac arrest, the survival is quite low, like about 13% or so. So prevention is the key. So if you're monitoring those that are at higher risk, then hopefully you can do more to prevent this. So that is the idea with this tool. I think the interesting thing here was the privacy issues weren't so big because the data was all inside a hospital setting in a sort of already, you know, heavily regulated. But then once we start to think about commercialization and taking it to other places, and this was a theme that came through quite often, was the innovators we were working with are probably a self-selected group who are very concerned and keen to follow all the rules and regulations and are doing privacy by design, trying to in their developments, but they don't really think through, well, what will happen when you actually commercialize it then? You know, will all of those sort of protections that, you know, are they built in? Are they baked in? Or will they just be discarded in the search for more dollars down the line? And then the last one we just did was an intelligent powered wheelchair. So basically a self-driving wheelchair. And again, this theme came up here where the innovators themselves are in Quebec, had done so much work thinking about privacy by design. And, you know, the potential with the self-driving wheelchair to collect data from all over the show was enormous, but they had made sure that that wasn't happening in their trial, in their research. But, you know, we were sort of pointing out, but what happens once you commercialize it, there'd be really nothing to stop all that data being collected in real time by the self-driving wheelchair, and it can go into some fairly, you know, intimate places and spaces and secure places, you know, airport security, these kinds of things. So, you know, quite a lot of really interesting issues there. So here is where the CIFAR, you know, French and English, if you just want our one, then there's the Machine MD, and there are other things, other pieces of work that we've done there and, you know, that you might be interested in. We're also working on a big scoping review, 11,000 documents that we've triaged, looking at how different disciplines think about the legal issues in AI. So what do computer scientists say are the top concerns? What do lawyers say? What do ethicists say? You know, what do engineers say? So we're trawling through all of this data. We built a big bibliography, and hopefully we're going to get that out soon. But that is going to inform some of my comments here now, as well as the case studies. So, you know, as is usual, these are the sorts of issues that have come out for us. And I think, you know, we're really still working through the richness of all of the insights and trying to figure out what we actually want to say about some of these things. So today I thought I'd just make a few comments about informed consent and about liability and safety, but happy to talk about some of the other things as well. And the other thing we have found is that they're very interrelated. You know, these kind of discrete sort of worries that we have in law are actually very interconnected together. So one of the things that I thought was interesting is that in our workshops and in our reports is that lawyers and actually ethicists and others in the room talked about informed consent in two ways and often conflated them when it comes to AI. So the first one was around consent to the use of your health information, of your data, whether it's identifiable or not. So giving consent to that. And then the other one was consent to the treatment, including AI. So these two were bundled together by our folks. And if you're health law geeks, right, you know what I talk about when I talk about informed consent to treatment. But many of our colleagues also talk about informed consent to the use of the data. And I found that really interesting that they were conflating the two. And I'm trying to sort of unpack. I think aspirationally, you might want informed consent to the use of your data, but I don't think that's what the law actually requires, whereas it does require informed consent for treatment. So that's something that we were figuring out. And as you know, so let's just talk about the first one. So the first one, sharing your health information first. And as you know, AI systems really rely on big data. And privacy law is all about sharing the minimum of data and only for the purposes for which it's strictly needed, right? So there's immediately kind of a tension between the objective of big data and health AI and privacy law. So we've got that kind of conundrum. And some of it is going to be coming not only from the electronic medical record, but potentially could be triangulated with, you know, all the Facebook data, the Internet of Things, and all sorts of stuff. So once you have that triangulation happening, there's obviously some real concerns about identification. And, you know, I think we're all familiar with this, where we just, you know, you read the oceans of legalese and you just click yes, because you know, whatever, right? You're never going to read this and you can't really argue with them. And so you're stuck with it. So you just say yes. Now, historically, the way that we've dealt with this in the health field is to say, well, look, if it's anonymized, knock yourself out, right? So we don't have your personal health information. It's not identifiable. It's anonymized, and in Canada, that means in all jurisdictions that you can use this anonymized data for health research and so forth and so on. But of course, you know, something of the irony here is that the AI itself is making this protection of anonymization less real, and particularly with the triangulation, right? So even if the physician is using an AI assist, and in theory, the AI assist is only picking up data that is then anonymized, it may be not that difficult, if someone really wanted to actually re-identify you subsequently, right? So what does this mean for the physician working with the patient? Does the physician have to inform the patient of this risk? Is this a material risk, such as it is the same for treatment? So the treatment, you're going to have a hip operation, there's a minor chance of a clot or whatever, they tell you this. Do they also have to advise you, well, there's a minor risk that your data could be re-identified? What obligations do they have, even if it's collecting actual health data, but it's not them collecting the data, but it's the machine that they are using to support their decision-making? What obligation do they have to correct that data, to advise them? And I've been, you know, I'm really in a rumination phase here, so apologies, but it seems to me that there's a bit of a risk here in the healthcare setting more than in other settings, because physicians and other healthcare professionals strive very hard to try to engender trust on the part of patients in their decision-making. Trust me, right? That you really, actually, if you don't trust them, you get in trouble, right? As a patient, you have to trust them. But then, you know, they are potentially this AI tool that they're using, which may be resulting in better decision-making, it's true, may be collecting your data and using it for all sorts of purposes. Trust me, you trust me as a physician. Do I also then put misplaced trust in the AI tool, or that assume that there are protections in place that may not actually be there? So I think this is something that we have to unpack, this idea of consent and trust in the physician and other healthcare professional. And as they're using these tools, it's not just like I'm using a diagnostic tool that doesn't have another partner that is viewing the data, right? The data can be taken and explored elsewhere. And so I think we are going to have to, you know, think about certainly how we overhaul our laws to at least prevent harm to patients that come about from the sharing of data at a minimum, right? So one thing to think about more is to, you know, render illegal both the sharing of data or the re-identification of data, and that is happening in a number of places, but also the consequences. So to prohibit discrimination on the grounds of health status by private insurers, for example, or by employers. So to try to prevent the harms from occurring so that people can feel more confident that they can share their data, or that if their data is taken and exploited, that there will be few, if any, harms to them down the track. But in the absence of that, it may be that the common law has to evolve here to consider whether or not informed consent includes informed consent to the to how the data will be used by the AI tool. Now, the second area related, of course, is informed consent to the treatment itself, supported by AI. And as those of you in health law know, this is generally governed by tort law, and a healthcare provider who fails to secure informed consent before proceeding with treatment may be liable for negligence. And the traditional patient-physician context, the physician explains the risks and the benefits of the said treatment and the different alternatives. But this, of course, gets a bit more complicated when it comes to algorithmic decision-making, because the physician themselves may not understand really how the decision was reached. Now, a lot of the time, that actually doesn't matter. They may not understand how a prescription drug kind of actually works in the body truly to get to the result it does. As long as they're able to explain to the patient the particular risks and benefits for that patient, then that's okay. It doesn't have to explain exactly, the physician will never have to explain exactly how the algorithm works, right? That's crazy. But what are the real risks and benefits to the patient? And that could be difficult, particularly because of how AI can evolve. And just like prescription drugs, when they come out of the trial and they go into the real world, how do they actually work in the real world? So, AI is trained on a particular set of training data, then it comes out into the real world and it meets people that it hasn't been trained on, right? So most of you know about this problem of what they call algorithmic bias. And algorithmic bias has two aspects to it from a legal perspective. One, I think, is very closely linked to safety. So the safety issue is that if it isn't properly trained on someone that, is like me, then it may be getting the wrong result. It may be diagnosing me incorrectly, or it might be giving the wrong treatment recommendations, but also just pure discrimination, right? So there's also the concern that you're discriminating against a particular group with using the AI tool. Not that you're necessarily getting the wrong result, but there's just this aspect of discrimination. So two sort of senses of this, and I think this raises the issue of, first of all, whether the regulator, the TGA in Australia or Health Canada, when they approve AI devices, should they come with warning labels like prescription drugs do? And then what's the use of that? You read those long, like chuck that over, right? So that's a really important question. But then on the part of the physician, does the physician need to warn an individual, look, this wasn't trained on data that reflects someone in, from your race or your gender or your age. So there's a risk here. Right? So do they have to inform them of that risk? And then, of course, if the risk is always falling on marginalized groups, what does that do in terms of access and justice and fairness, right? So the same people, the divide between the haves and the have-nots could exacerbate here. So I'm not sure it's like a get out of jail free card. We just sort of slap a few warnings on and Bob's your uncle. I think we need to think about that quite a bit more. By the way, the warnings aren't happening yet either, but that would seem to be something that will likely evolve. Now, one thing that comes about, if I shift now to sort of safety and liability issues, but again, you can sort of see the relationship here, is that in a lot of what we see and in the debates that we have is this issue around having a human in the loop or a provider in the loop, right? So having a a physician in the loop. And in the Canadian milieu, in the regulatory milieu of medical devices, having a physician in the loop means that you have less regulatory oversight. So you have a lighter touch on the regulations if there is a physician in the loop. In Quebec law, if there's a physician in the loop, you don't have to advise them that the AI machine, well, it actually hasn't been passed yet, but they're proposing this. You don't have to advise them that they're collecting your data because there's a physician in the loop. And so in our case studies, we really have, I think, challenged this. Okay, so part of the reasons why we want AI to support physician decision-making is because sometimes they make crappy decisions, right? So you want the AI to help make better decisions, but then somehow the superhuman doctor who was making decisions before is now meant to turn around and be able to second guess the machine or second guess the algorithm. That doesn't seem like the best sort of assurance of quality and safety, and yet it seems to be one that's relied on again and again. And I think the folks in the humanities are really guilty of this because we over-romanticize human decision-making. You know, if we just have a human in the loop, it'll all be okay, it'll be rainbows and ponies. And it actually is a real risk here that the AI may be well making better decisions, but we're putting a lot of freight on the physician to make the decision that they won't actually follow the algorithm and potentially harm the patient as well. So that's the opposite kind of worry. So over-reliance is a worry and under-reliance is a worry as well. Yeah, and then another issue that we see coming up is physicians want to be in the loop because they're all worried about losing their jobs. So I was part of a big task force, College of Physicians and Surgeons on AI. This was the thing that came up again and again, is that, you know, they'll get made redundant, radiologists will get made redundant in 2 seconds flat, la, 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 la. And the refrain back was, no, you don't need to worry about it because the provider will be in the loop, right? It will be AI supported human decision-making. That will be the future. And, you know, okay, that's great. However, if I'm a lawyer advising the AI innovators and manufacturers, what I'm going to be doing is drafting these contracts to make sure all the liability flows down to the user and away from me, right? That's what you do as a lawyer. It's a good job. Okay. So the provider who wants to be in the loop will now actually have to carry the freight of being in the loop. What does that mean, right? So I think we probably are going to need some regulation of how these contracts work, or the common law is going to have to evolve to really think this through. Is this the right place for the freight to be placed on the healthcare provider or the healthcare professional here? And, you know, I think that is a concern. Now, I think where we've got to with some of this is that most of us are of the view that relying on private law here, on tort law, so medical malpractice law, and negligence law and contract law is probably not sufficient. And those of you who work in health law know the tremendous uphill battle that there is for a patient to bring a successful medical malpractice claim. Very, very difficult to succeed in, very costly, very hard to win on the causation part of it. So that is to show that the actions of the physician actually caused the harm that I suffered, and it wasn't because of some other thing that I caused the harm. And I have the burden of proof as the patient to show that. Really tough to do. Even more tough, right, with algorithmic decision-making. How am I going to show that the algorithm made a mistake supported by the physician in order to be able to show causation sufficient to attract liability? And you might say, well, that's good because that innovation will fly, doctors will be happy, you know. But I think it is a problem because you're not sending the right set of incentives back to the innovators and manufacturers to do a good job, right? To create fantastic AI that is beneficial and safe for us all. You're actually sending incentives. Look, you can design crappy AI and you're going to get away with it. patients are harmed, you may never actually have a reckoning. So that's problematic. And I think that's why we should be thinking more around ex-ante regulation, that we need to have more preventive, appropriate regulation of health AI to prevent the harms from happening in the first place as best as possible. And I think I've at least persuaded the innovators that we work with that this is actually in their interest, because the good innovators will benefit from adroit, efficient, appropriate regulation, and you want to weed out the bad ones, right? So if you have bad AI innovators in the healthcare space, it will only take one or two, catastrophes for the whole endeavor to be set back significantly, or perhaps over onerous regulation like red stop regulation kind of coming to pass. So here's my final slide. So this is where we are moving to then. And right now there's a bill that Canada has promulgated. It hasn't been passed yet, to actually have oversight of what they are describing as kind of high impact AI, and to have more regulation of that area. It's actually, I'll be blunt, it's a really crappy bill. You can drive a truck through it, it's hopeless. And so we have no idea what it really means. They just wanted to pass something before the election to say they're doing something about AI. Great. But it's unclear what it really means and how it will lead with regulation of medical devices with AI, which is already sort of in place. So to cut to the quick of this, the problem is that our regulatory approaches, which is why the innovators are not so keen on regulation, are dinosaur-like, plodding along, and very slow and not particularly innovative itself, right? So the trick is, how can we have innovative regulation to match the innovation that's coming through? And actually, in fact, how can regulators use AI themselves to better regulate, to better monitor AI? And so once we get into, which we already are, a world of machine learning, the old idea with a medical device that you approve it as safe enough, right, for dispersion in the market, and then you let it go, and that you recall it if something terrible happens to a whole lot of people some years down the track. I'm a bit cynical. But with machine learning, by definition, this thing is changing over time. That's what you want it to do. You want it to evolve to be better. It's changing, might be quite a different thing from when you first approved it. So up until recently, they wouldn't actually approve it. It was just too hard. They couldn't get their regulatory minds around it. Now they are saying, well, let's play in the regulatory sandbox. I'm like, what the hell is that? They're like, well, we're just physicists. We don't know. There are no lawyers that are part of the medical device and directorate team, which is to me a bit of a worry. So they talk about playing in the regulatory sandbox. And by this, they mean they're going to create kind of bespoke regulation for each machine learning device that comes through. And I think the worry here is that the focus in Canada, US at least, and I think Australia, is very much on fostering innovation. And our regulator is very focused on that. And I keep raising the question of, is that your job? You're meant to be protecting safety and quality. Like, you're not over in Industry Canada. Industry Canada could give subsidies as much as they'd like to innovators, and I'd be very happy for them to do that. That's a different thing from saying we're going to have a lighter regulatory touch because we want to foster innovation. That doesn't seem to me to be the right frame. The right frame should be, we are focused on public safety and quality. How can we do this most efficiently and well, and adapt and evolve? We don't want to put regulation in for the hell of it. We don't want it to be heavier than it needs to be, but that's a different thing from saying we're just going to have light regulation because we want to foster innovation. That's wrong to me. So, but there's, I think as lawyers and people who think about public policy, we really have to evolve our regulatory kind of approaches and how we think about things. So green light, red light, not so much, right? We need monitoring over time. We need to think about the ways that AI works and functions, when there may be signals of problems, how you would detect those signals, how you would have that reported back, what action should be taken. I mean, I think the good thing about AI is that, you know, unlike having to recall a whole lot of prescription drugs, you can just ask them to fix the algorithm, right? And it's not like you're going to have a huge issue here. So you can be monitoring, improving things on the go in ways that you haven't been able to before with prescription drugs and traditional hard medical devices. So I think there's a lot of opportunity here, but we're really going to get our thinking caps on. And so that's where we're tuning to next, and working on now. A big comparative project that's looking at the regulation of medical devices across different jurisdictions and how we should think about it from an innovative perspective. I'm sorry if I've rabbited on too long, but it's been lovely to talk to you and to share with you some of my thinking. And thanks for having me.
Thank you very much, Colleen. That was amazing. So I'm sure there's going to be questions to try and explore it a bit more. So, so when you ask your question, would you like to say who you are? So Colleen has a bit of context. Thanks.
I'm Ben Bartle and I work in philosophy. I'm concerned that in a way the patient becomes invisible in your talk. This probably brands me as an incorrigible romantic, but I'm of the school who thinks patients, their advocates and family are the first and last defence against bad medicine and bad health. And let me give you 3 quick examples which are sort of pre-AI but connected. So somebody I know was a patient in hospital, and the nurse would come in, she would check the machine, she would check this person's barcode and do whatever that's required, not talk to the patient, just leave again.
Yeah.
The machine was running the show, both for the patient and for the nurse. Second example, same hospital, same patient. The nurse wants to administer some medication. The patient points out it's a neuro drug. The nurse says, yes, sure. The patient says, no, I'm actually needing a analgesic. And there's an argument about this, and the machine for quite a bit of this conversation seems to dictate what should be administered to the patient. Third example, again, I think the patient just disappears. In this case, my son. He says he's distressed because he's not being sufficiently respirated. The nurse says, no, the machine says the oxygen, your blood oxygen levels are adequate and your distress is unwarranted. I mean, he rings me, he says, can I come in for a couple of hours to assist him? So this kind of machine-regulated health system is already in operation and people are suffering from it.
Yeah, thank you very much for your comments. And I think that's important. And I should have mentioned, and I did actually have that in to discuss the problem of automation bias. So that is, our concern where we're saying we've got a provider in the loop, and so everything's rainbows and ponies. If the provider, like many of us, I can't actually drive even to down the road now without turning this thing on, without, adhering to the machine itself. So that is it's being established that this is an issue, and it's something that we have to take account of when we think of legal reform. On the other hand, I guess I'm not as pessimistic about you. I see some of the incredible improvements that from the people that I've been working with, and the patients that we're working with are very excited about the prospect of improvement. More people die in the US from medical error than in hospital and in road accidents already, right? So it's not like before. It was wonderful. It's terrible. And And then it's so very difficult for patients to actually receive any kind of compensation or to be able to bring a negligence suit. So I think perhaps, this opportunity to really rethink our legal paradigms here might be an opportunity for patients to be better protected as well. So, let's hope that we can actually make some improvements here, both really for patients in terms of the healthcare they receive, but your point about automation bias is a profound one and an important one and has to be factored in as we think about law reform.
Questions for Colleen?
I'm a senior lecturer in computing and information systems. So I was thinking while you were talking, do you see a role for citizens' juries in these kind of deliberations in this policy formation, or is that something that you've
Yeah, I haven't thought about citizens' juries. I mean, there can be certainly the times that we've been using or I've been involved with citizens' juries are really when we're trying to, in Canada for years, we've not had prescription drug coverage. And it's just got the Liberal government promises it every time they get elected and then they never do it. So we're involved with citizens' juries to try to actually finally push this over. Perhaps with AI, I mean, it's such an enormous area. I think we have to be clear about what we want first, though, to sort of say, well, here are the options and here are the pros and cons of all these different options, and then to ask citizens to engage with this and how they feel about it. I think that the thing is that, my area of interest is really healthcare, and I work with a lot of people who are working on AI more broadly. And there really is a schism, it seems, between people who think, that the existing laws we have are sufficient and others who are really looking for big bang reform. So I think we have to figure out, the big bang reform people need to figure out exactly what that's going to be. And I think it's actually different in healthcare because of, for example, this provider in the loop idea and the fact that we already have a lot of regulation of hospitals and so on. So let me just give you an example of one of the things here that I wanted to mention and didn't, was our medical device regulator at the moment, for example. If you are doing AI within a hospital, so my friends from Sick Kids, there's no regulation of that. So they're coming up, making all of this stuff, and as long as they just use it within their own hospital walls and they're not transferring it to anybody else, it doesn't count as sale. So it's not governed by the medical device regulations. Now, I love my friends and they are amazing innovators, so I'm perfectly comfortable with what they're doing. And there is, quality and safety governance within the hospital, so it's probably okay. But, I think there's sort of some really interesting kind of holes in the medical device regulations that we need to really think about. So, yeah. Great question.
We've got a question online from one of our students here at the law school, and they're interested in your views, Colleen, on whether and what the liability position should be if an AI developer can show that on average, but not always, that a particular AI system is more accurate than its human counterpart. So it won't always be better, but it will on average be better. Like how do we approach liability around that?
Yeah, so the liability, so first of all, on liability, the question always becomes who's liable? Is it the innovator? Is it the manufacturer? Is it the hospital? Is it the healthcare professional that used it? So, or is it all of the above, depending on the context? And usually a patient is going to go for the deepest pockets. Physicians are concerned that they will always go for the physician regardless of where the blame should really lie. Sometimes that's appropriate because, at least in Canada, the physician's insurance is all covered by the public sector anyway, so we're paying for it anyway. So they will go for the deepest pocket. So on average, the question is, have you actually, have you alerted the users of the product of when the average might not be So yes, on average, that's great, but if it's very clear that the AI tool, or you should know that the AI tool will not work on a particular racialized group, or it has not been tested on them, and so that there's a risk. And particularly if then the tool itself is actually used primarily on that group, right? So then it becomes even more clear that there is some kind of a duty on the manufacturer here to warn. But every jurisdiction has its own kind of product liability rules, which may be more or less stringent in terms of the liability that it puts on the manufacturer. So you have to kind of look at that first. I'm not sure what they actually are in Australia, I'm sorry. But then aside from that, it will be, you know, is this something that a reasonable, was there a standard of care owed by the manufacturer to the patient? And that will depend on what they should have known or did know, whether or not they warned. But as I sort of mentioned before, I don't really think that just the warning thing, you know, this is a traditional tort law. I warned you something really bad's going to happen to you, and you're like, well, you always warn me of that because, you know, I'm from a racialized minority group that you never do any research on with a rare disease. Thank you very much, right? Nothing works for me. Or pregnant women, another group, right? And nothing. So you warn me every time that I'm basically going to kill my baby if I, you know, take this medication, but I have to take the medication. So thanks a lot, right? There's not really a great solution to, I think, what patients really need, you know, so I think we need to try to do better than that. And this is why the privacy issues become big. So if the irony here is that marginalized groups have historically been treated badly and do not necessarily want to share their data. They don't want to share their data, which is understandable enough, or it's very complicated to secure the data from them. They don't provide the data, so then, I'm not putting on them, but the data is not secured, and then the AI tool has not been developed on training data that reflects them. Then it doesn't work well on them. Then you say, well, sorry, it doesn't work well on you. It's kind of like this vicious circle. So I think the issues around data protection, data governance, and privacy, how this all links up together, this has to be tackled somehow. And so I think governments need to be probably investing quite significantly in how to ensure protection of people providing their data and encouragement and support to provide that data.
Thank you. Is there any other question in the room? Yeah.
My name is Annika. I'm a Canadian international student studying my JD here. I'm interested in this area of law that you're talking about. What would you say are the opportunities to get involved if you want to pursue this type of law?
I think it's enormous, you know, it's just exploding. So obviously in the medical device regulatory framework, I think right at the moment, anything in privacy law is and the intersection with big data, electronic health records, machine learning is just exploding big time. So I think there's opportunities in the public sector within government as part of the regulatory side of things. There'll also be opportunities within health technology assessment. So as all of these products are coming to market, it's actually going to be, you know, some big decisions are going to have to be made about resource allocation and how you decide what to publicly fund and what not to publicly fund. And many of them will be more bespoke than ever before. You know, the actual costs of production here are a lot lower than they are for prescription drugs or other kinds of medical devices. So I imagine there's going to be a torrent of innovation coming to pass. So how do you decide what to fund and not fund? Then in the private sector, you know, working for companies, hospitals, physicians, a lot. So the IP side I haven't even touched on, but of course that will be significant as well. Yeah, I think the world's your oyster on that one.
Okay, we'll just take, there's one more question online, and it's from another one of our JD students who's asking about whether you think regulatory bodies like the TGA and Health Canada form a quote adequate barrier in preventing badly designed healthcare AI from entering the healthcare system.
Well, no, So I don't know too much about the TGA just yet, but I understand that they're all kind of tracking along together. So they're part of a collaboration that meets occasionally the medical device regulators. And so they're all sort of singing from the same prayer book on a lot of this stuff. Although we do see quite significant differences, for example, the privacy side of things between Europe and the kind of North American model. So I think that's going to be a real question for Australia. Do you follow the sort of European model? You follow the North American model? You know, in Canada, we're just like, whatever. We're following the North American model. Up until now, as I mentioned, Health Canada just wasn't approving machine learning devices, right? They could only approve kind of fixed AI. So it's fixed and it's not evolving. They could give it a green light, yes, go forward. But there are all sorts of holes even in that. So the regulator, the innovator itself, the manufacturer itself picks which risk category it falls into itself. So it decides if it's low risk or high risk. And so we were trying to find out, well, like, how do you audit that? And the kind of answer back was just trust us kind of thing. We're like, kind of like to see, you know, how are you checking this, their own decision making? Then, as I mentioned, the kind of the hole within that, if it's within hospitals, they do it themselves. And then the problem that they just weren't permitting machine learning. Now they're permitting, in theory, machine learning, health AI, but it's really unclear how they're actually going to regulate it. So there's not enough transparency about what they're doing. And I think, you know, you asked me about a kind of jury thing. What's really important to engender trust in this is that there is transparency. You know, you have to have transparency about the regulatory process, about the mistakes that we're all going to make. You know, mistakes will be made. We might do the wrong kind of regulation at first. That's okay. You know, it's better to test it out, because just like innovation, we have to, I think, give it a go and see that if we're doing the right thing and evolve it over time. But you have to be honest with the public about, look, we put this in, it didn't work. So now we're going to experiment again and try this other thing. So I was telling Paula that I'm also part of another, with Anna and other colleagues, looking at an innovation that they're working on, which will actually is an AI innovation to monitor the health AI. So it basically tries to predict the risk, for example, of algorithmic bias of a particular AI tool for a particular subpopulation, you know, in this hospital. So a hospital sees like a whole lot of, inner city hospital sees a whole lot of migrants and so on. This tool that they're working on will give risk boundaries for the clinician to say the chances of this being successful are between X and Y. Right, so it will help them make better decisions. And I think that's fantastic, right? So as a regulator, if you can rely on that kind of tool to help monitor the AI innovations over time, then that's got to help. So that's what some of the stuff I'm talking about getting a bit more savvy about how we regulate. In fact, using the tools that are befuddling you to actually help you make you a better regulator.
Thank you. Thank you very much. So we're right on to, maybe just a little bit after. So please join me in thanking Colleen. It's wonderful to have her here. Just opened up such a big bag of issues for people to think about. I'd like to thank everybody for coming, thank all our students for coming and colleagues, and thank everyone online. So thanks very much. Have a great day, and we'll see you again. Thank you.